Hi and welcome back to the EFWU Union podcast. I'm your host Paul today and we're tackling a topic that many of us know too well, all too well. That's injuries at work and in general health and safety. So whether it's a one-off accident or a long-term condition caused by poor conditions, it's vital that you know what your rights are and what support there is out there for you as union members, as members of the EFWU. Today, I'm joined by Alex, who is a personal injury lawyer with years of experience representing working people in injury claims. And I'd like to say welcome to you, Alex.
Thank you.
So we're going through various segments. So the first one is what counts as a workplace injury. So I'd like to ask you, Alex, what is a personal injury in the workplace? What does that actually cover?
Yeah, of course. So a workplace injury is really broad, actually. So it covers one-off accidents or things that happen over a period of time. So there's some conditions such as, say, carpal tunnel syndrome or even hearing loss that might not become apparent straight away. And it also includes not just physical injuries, but also psychological injuries as well, whether it's workplace stress or just a psychological reaction to an accident that's happened as well. So it's really broad a spectrum.
Yeah, okay then. We're going to talk about time limits later on as well. We'll cover that for reporting accidents. So if you could explain physical and mental injuries, slips, trips, faulty equipment, lifting injuries and psychological harm, if you could just go a little bit more depth into that.
Yeah, of course. So physical injuries, they can be caused in many ways. Some of the more common injuries that we see are slips, trips and falls, but they can also be to do with lifting excessive amounts over a period of time or a one-off accident. They're the most common ones, but like I said, it is just a wide range. In terms of psychological injuries, I've helped many clients where sometimes they don't even have a physical injury. They may have just seen something shocking at work, such as I've had a case where unfortunately, a client's lorry set on fire. He did manage to escape without...
Was lorry set on fire?
Was lorry set on fire while he was inside that, while he was asleep. Fortunately, he did manage to escape without physical injury, but he was left with post-traumatic stress disorder. I am actually representing him, and even though it's no physical injury, because it's still as a result of the defendant's negligence, we can still claim for that.
Yeah, that must have been scary. So distress or repetitive strain from poor posture, they count, don't they? They count as injuries.
Yeah, definitely. So in terms of if you're working at a desk, a company does need to complete what's called a desk assessment. And so they have to check that the equipment is suitable for use. And it is the correct height. And as well, if you do have any pre-existing injuries or if you are suffering any discomfort, do just tell your employers about that, because they should make reasonable adjustments for you. For example, they could give you a desk that rises, or they could give you a wrist support, for example. So it definitely does include those injuries.
Yeah. So, is that a legal requirement for the company or the organisation to carry out a display screen equipment risk assessment?
Yes, that's correct.
So that's worth getting that across to members. If you're working at a screen, that your company should do a DSE. They don't all do it. I know from experience myself that they don't do it, but it's a legal obligation. They do have to carry out a display screen equipment assessment.
Definitely. It's important as well just to know as well, even if you work from home, that assessment still needs to be done.
That's a good point. That's a good point. With so many people working from home now, and since COVID, carrying on working from home, it'd be interesting to know how many companies are actually doing that when people are working from home, and whether they are aware that it's a legal requirement. Yeah.
Unfortunately, we see many cases where these assessments aren't done, and they're especially neglected when a person does work from home, but that is still a requirement.
Yeah. Good point. So we're going to cover as well, if you can, that it's not just the obvious accidents, it's long-term impacts too. Could you give some sort of an example of that? I mean, you mentioned carpal tunnel syndrome.
Yeah.
These are the type of things that, it doesn't happen straight away. It can come out later in life. Do you want to give any examples of that?
Yeah, of course, definitely. So we see examples where people work on a production line. They may be doing something which, say, as a one-off incident, it may not seem dangerous, but when you are doing something repetitively over a period of time at excess, it can really impact the person. So say, for example, carpal tunnel syndrome, It can sometimes take years to actually become apparent. When those situations happen, it comes from the date that they have the symptoms rather than the date they started working there. So that's just important to know.
Yeah. And as I say, we're going to talk about time limits, and we'll cover that then, because it's not just the time limit, it's from when you become aware that you're suffering from an industrial injury.
Yeah, definitely, because it's not always apparent straight away.
Yeah. And I think another one, quite a few that I've dealt with, and that's hearing loss. Hearing loss, obviously, that doesn't happen straight away, and that can happen over time.
Yeah, definitely. I know there's a scheme at the moment for the military, for example, where people are claiming where they've worked in the military in the 80s and 90s and they're only just being diagnosed with a hearing condition now. Even though it was decades ago, that still does fall under the scheme, because people sometimes don't have these for 20, 30, 40 years down the line. So it's still able to be claimed for.
Yeah, and I've dealt with a few cases with hearing loss. Okay, so we're going to move on to what we're calling segment 2 now, and that's the law is on your side. So, Alex, what responsibilities do employers actually have when it comes to our health and safety at work?
So there's quite a few. To start with, the employers do need to provide a safe system of work. So if they're completing a task at work, they have to make sure that it is done safely, and they have to provide adequate training. And it's not enough just to train someone as soon as they join the company. It has to be regularly repeated. If an employee isn't completing that training and they're not following the instructions, it is important that the employer does either retrain them or they have to discipline the person, because they have to protect the other employees. We've often seen situations where employees are just completely ignoring the training, the employee's done nothing about it, and then unfortunately another person just become injured. There's quite a few other things as well that the employer has to do. They have to ensure that they provide safety equipment, such as personal protective equipment. It's not enough just to provide any protective equipment. It has to be suitable for that specific job and the specific person's needs. So you can't provide equipment that doesn't fit. And we've had examples before where, say, safety goggles have been provided, but the person needs prescription glasses. So, of course, if they're not fit to their needs, they're pretty much useless. So they have to make sure that it is adequate for that specific role as well.
Yeah, and they have to carry out risk assessments again, don't they?
Definitely. They have to risk assess every task. They have to make sure that they consider all of the risks, even if it's quite low, and they have to consider what can be done to prevent injuries from happening. It's important as well, where an accident does happen, that they do review those risk assessments as well, just to prevent this reoccurring again in the future. I've seen situations before where risk assessments are so poor and so brief, it's just not suitable. It has to be in detail.
Yeah, and all that information's there as well, free, isn't it, to the employer? It's on the HSE site, Health and Safety Executive site. So I know there's a booklet called 5 Steps to Risk Assessment.
Yeah.
So it's all there, and it's no excuse, that it's a big cost to the company, because it's all free and it's all on that site,
Yeah, definitely. Just because you're a small company, it doesn't mean you can't follow health and safety. You do need to protect employees.
Yeah. Okay, then. So if you could explain the employer's duty of care under the Health and Safety at Work Act 1974, for risk assessments, training and safe systems of work. I think you've covered some of it already, haven't you?
Yeah, of course. So in terms of the employer's duty of care, they have to take steps to ensure that the employee is kept as reasonably safe as possible. And that doesn't matter if they're an agency staff member or a direct employee. It does apply to everyone. Like I said, it is all reasonable steps, so it does depend on the task completed, but they do need to consider even, for example, a person's individual characteristics as well, where, for example, they might be at higher risk than other people. Say, for example, if a person has a disability, they have to take that into account.
Yeah. And are they also responsible for somebody coming on to their site that's not employed by them to do work?
Yes, so if they do have a third-party contract on their grounds, they have to make sure that they are adequate for the role. And at the end of the day, they have the overall duty to protect the employees whilst they're there.
Yeah, very good. And what happens if they fail in that duty and somebody gets hurt? Can they be legally held responsible? And if so, how?
Yes, so to start with, employees should, of course, inform someone that the accident's happened. If a company has 10 or more employees, they have to have an accident book. So this means it has to be recorded in there, and it also includes near misses as well. So if an accident almost happened, but fortunately no one was injured, so it must be reported in there. If an injury is more long-term, or if a person needs, say, a week or more off work, it has to also be reported to the Health and Safety Executive in what's called a RIDDOR report. It's then up to the Health and Safety Executive if they want to investigate this further. I've seen situations before where companies completely failed the employees and have actually then intervened and have either made some recommendations to the company, or they can actually, in the worst case scenario, they can actually prosecute the company for failing to protect their employees.
Yeah. Okay, under RIDDOR, as you say, they have to report. I think it's a 5-day injury. Over 5
yes,
days.
so any long-term injury as well, and it also includes repetitive injuries as well, so it's not just accidents. It can be, there's a whole range of things that need to be reported, but it can include long-term conditions as well.
Right. Do you think there's a reluctance on the employer's side to report things under RIDDOR because it's sort of reporting themselves, isn't it?
They can be. Fortunately, I do say in most scenarios it is still reported because, as I said, it is a legal requirement. In most situations, if it is reported, the company has to say what they can do to prevent this from happening again, and there may be no repercussions on them. Like I said, it is in those extreme situations where they do intervene and prosecute companies, but it can happen. But fortunately, like I said, most companies do report it. I have unfortunately seen some companies that haven't recorded it in the accident book, which is a bit more common.
Yeah. Does it have to be an accident book, or can they have something else like reporting it online instead of, or do they have to have an actual physical accident book?
So every company can have their own procedure. So for example, the NHS have something called a DATIX report, which is essentially an internal online reporting system. So as long as it is reported adequately somewhere, it doesn't need to be a physical book, they can be online.
Right, okay.
But it has to be accessible as well, so it can't just be hidden.
Yeah. Accessible, obviously, to the people, the person that's maybe had an accident.
Yeah, of course, people should be informed where it's kept and how to report it. I've seen situations before where employees have told me they don't know where one is, they didn't know it existed, even though it is a legal requirement.
And they don't know how to report an accident. And they probably, some don't know that they have to report, but they should be reporting an accident.
Yeah, definitely. I think some people are just concerned about reporting it because they're worried about the job. But at the end of the day, employers do owe you a duty to keep you safe at work.
Yeah. Okay, then. So we're going to move on to segment 3 now, which is how to make a personal injury claim. So if a union member, or anybody, to be honest, gets injured at work, what should they do?
So the first thing is they should report it to the company. Firstly, it's just obviously just make sure that it's all recorded in there correctly. But it's also, like I said, just to make sure that it is reported to prevent a further reoccurrence. Just because it's happened once, it could happen again. So it's important that the company is aware of what's happened. It's also important as well, if the company can provide first aid, which it should provide, they do get treatment as soon as possible. It should also really be sought from a GP or a hospital. Firstly, just obviously make sure that their injuries are diagnosed and treated correctly, but it's also important to make sure it's logged. Like I said, I've unfortunately seen situations where companies haven't recorded this in the accident book. If a client hasn't then got medical attention and there's no other evidence, it can make the claim very difficult. So it is important to get medical attention as soon as possible.
Right, okay. So I've got down here, report it immediately to management or your union rep, which is, you've covered that here. Write it in the accident book, which you've covered that, or whatever means they have for reporting.
Yes.
As you've just said there, get medical help and keep copies of any medical records. Also gather evidence. You need to be doing that as soon as possible. Do you want to give us some advice on what they should do for gathering evidence?
Yeah, of course. So evidence can be really broad. It can include photographs, say, if it's a defective equipment or if they've fallen over something or something's unsafe. It can also include taking details of any witnesses. As well, if they have complained about something, even before an accident's even happened, if they've done this, say, by text, WhatsApp, email, any of the kind of written documentation, it is important that all of that is kept. Some people have told me before that they have verbally complained about things, but then companies can sometimes deny that it's happened, which is obviously very frustrating. So it's important that they do keep any reports they've made. Like I said, an example is text and WhatsApp, because it means they can have access to it and leave the company then.
Yeah. And witnesses as well, anybody in area that saw the accident or anything like that, yeah?
Yeah, definitely, because I think as well, sometimes employees can leave the business, and if they don't have the contact details and want to call them as witness, it makes it very difficult then if we can't get in contact with them. So it's important that they do obtain that information.
Yeah. Okay, Alex. I've got 5 years speak to the union and get legal advice early. What happens in your company? Does the member or the person that's been injured contact your company directly?
And so usually they do go through the union, but they can of course contact us directly if they wish to as well. It is of course important to get legal advice as soon as possible. It doesn't mean that they're bound to go forward with a claim, but just even if they get the initial advice. And the reason why it's pretty key to get early advice is some evidence isn't available over time. So for example, CCTV footage, it just all depends on the company's policy, but usually it's only kept for a couple of weeks. So say if you want to make a claim 6 months later, that footage may no longer be available.
Yeah.
And as well, I know we was talking about witnesses as well. Obviously, people's memories fade over time, so the quicker you can get those statements, the better.
Yeah. And photographs as well, yeah.
Definitely.
And we're moving on to timescales now then. So how long do they have to bring a claim?
So technically, they do have 3 years. So if it's an accident, it's 3 years from the date of the accident usually. But like I said, that the sooner they bring the claim, the better, just for evidential purposes, really. Technically, they do have 3 years to claim, but at the end of the 3-year period, the case can continue. But they do need to issue court proceedings before that, just to allow the case to continue.
Yeah. And I think it's 3 years from when they become aware that they've been injured at work.
Yes, that's correct. So say, for example, I was talking about carpal tunnel syndrome, for example, and they could have been completing this unsafe act for years before, but it's the day that they become aware of the symptoms.
Yeah.
And it has been caused by the workplace. That's when the time frame runs from.
Yeah, it's important to know that, they are pretty strict with the 3-year rule, but as Alex has just said, it's from when you become aware that you've been injured at work. It could be anything. I mean, we go back to, a lot of years when they had miners that were suffering from black lung and what have you. Obviously, it don't come out straight away. It happens over time, over decades. Cancers can lie dormant for decades,
Especially, say, mesothelioma, the asbestos-related cancer. Sometimes it's 40, 50 years down the line when those people are unfortunately diagnosed. But it is from the date of when they become aware.
When they become aware, yeah. What happens if you're out of time then?
So technically, you may still be able to claim out of time, but it does all depend on the court granting you permission to bring the case out of time. This is quite risky because, as I said, it is at their discretion and it does usually need a good excuse. Unfortunately, the court doesn't accept that someone just didn't know they can claim. That is not an excuse that's accepted. So would recommend definitely bringing the claim within the 3-year time frame.
Yeah, so as soon as you know, contact either union rep or the solicitors and start the ball rolling.
Like I said, even if it's just for the initial advice, I've had situations before where I've given some advice to someone within the first 6 months and the advice been, look, I'm not sure if I want to go ahead yet, I've got something going on. So that's absolutely fine. They come back to me, say, a year down the line, it's still within that 3-year time frame and I can begin the claim for them. But they've given me the initial, say, evidence and when they've spoken to me and then come back to me later. So that's always an option as well. They're not pressured to go ahead straight away.
Okay. What about the legal costs of making these claims then?
So I think a lot of people are concerned about the costs and they think that they'll be charged thousands of pounds, which they can't afford. That's just simply not the case. And provided they're honest and cooperate with us, it's no and no fee basis. So this means if the claim fails, they're not responsible for any charges. We simply close the case and that's the end of it. So they don't really lose anything financially by doing this. If the case is successful, it is just a percentage of the compensation that we take, and it is a maximum. So we do, of course, deduct any legal costs we're entitled to from the insurance company. In some situations, we don't need to take the full deduction, and the client actually receives the majority, if not all, of their compensation.
Right. And what, if you do take a percentage, you know what percentage you take?
Yes, so it's 25% plus VAT, making a maximum of 30%. But like I said, it is a maximum. I've seen situations before where people have actually got all of their compensation or the majority of it, just because we've got so much of what's called fixed legal costs from the insurance.
And you've been able to claim those costs back from the other side?
So we can get fixed legal costs, yes. It's basically, the reason why it's called fixed is it depends on how much the case resolves for. So the higher the claim, the more costs we can get back. So I've seen situations before where I've run a case for a number of years, but because of how much we've got back from the insurance company, the client's still got the compensation, the full amount.
Yeah, good. So segment 4, we're looking at the trade union's role in injury claims. So the first question, what role does the union play in personal injury cases? I think on that one, what it is, it's when you've got a union rep in your workplace, you should go to your union rep and let them know you've had an accident. Then they'll get the advice off the union rep. Obviously, the first advice they'll get is make sure that you've recorded it. And then the union rep generally takes that forward by contacting companies like yourself and telling them all about the case, then getting an interview with a member.
Yes, definitely.
Or you might do a site visit as well, depending on what the accident is.
Yeah, definitely. Especially say if an accident's involving unsafe machinery, for example, or excessive noise, excessive vibration, things like that. Sometimes you need to do a site visit. Like I said as well, if people have got photographs, that really helps as well.
Yeah. Because some of these things are difficult to explain. Because no disrespect to the legal side of it, but I'd suggest that the majority of people that work on the legal side of it may not have worked in a manual job on the shop floor. So, it is useful to have that site visit. And I've dealt with a few of these myself. Trying to explain it over the phone or, write things down is difficult. But, if you get somebody on a site visit, they can actually see what has happened. Yeah,
definitely.
Okay.
I'd say every case is different as well. I've worked in personal injury for 7 years, and yet still people are coming across new forms of accidents or new types of equipment I've never seen before. But so it's always about just continuously learning for both of us. But most of the time, like I said, I'm confident in dealing with the type of equipment that they've handled.
Yeah, and everyone can be different, can't it?
Yeah, definitely.
So first line support, helping report the injury. I think we've covered that. You do it through your union rep. But also, at the inductions at the company or the organisation, they should be telling the staff these things, the workers these things about how to report, an accident. Connecting members with legal services. That's the trade union role as well. If it's if you're in a trade union, the trade union would do that.
Yeah.
For you, and that all comes in with the cost, the price of your membership. What about documenting unsafe practices before and after the incident?
So if you notice any issue at work, whether it's something unsafe, such as the way of working, or if it's unsafe equipment, or maybe someone's just ignoring the training, it's important that they do record that. So I've seen many situations where people do complain verbally, which is great, but it's then sometimes difficult to prove that complaint has been made. So I know, going back to the point where I said before, if someone can report this by some form of written form, even if it's just a text message to the manager, just to make sure that they can prove that they have complained about this and the company's still ignored that. It does always support their case. I've seen many situations before where people have been complaining about things for such a long amount of time, and it only gets to the point where someone becomes injured that the company then unfortunately decides to change working practices. It's just frustrating that in so many of these situations, accidents could have been avoided.
Yeah. And can a worker refuse to do work that they see that's unsafe?
They shouldn't be working unsafely. Obviously, they shouldn't be getting injured. They should be informing people that they're not happy doing that. Because at the end of the day, you don't go to work and shouldn't come out injured.
Yeah, true. So we're talking now then about backing you in grievance or formal processes. So some workers could put in a grievance if they're not happy with if they're being made to do a job that's unsafe. Yeah, do you want to talk about that?
Yeah, of course. So a formal grievance is kind of a formal complaint where it escalates, and companies should have internal policies in terms of how that is approached. Especially you are usually allowed a union representative, for example, to support you with that meeting, or someone that's independent. So it is important that you do take the opportunity just to make sure that everything is recorded correctly as well. And if you do follow the formal grievance procedure, just make sure that everything is complained about formally as well.
Yeah. And it's important to note that, there are laws surrounding this, and you have a legal right to be accompanied to a grievance by a union rep or anybody else of your choice. So what about pushing for workplace-wide safety improvements after a claim?
So, as I said, when you do formally report the accident, it can go to RIDDOR, completing a RIDDOR report to go to a health and safety executive. They can, like I said, intervene and just make any changes to the company as well. If a case is made as well, it just go through a company's insurance company, which can, of course, result in the insurance premium increasing for the company. So there is, of course, some sanctions on that. Sometimes insurers can, of course, then say to the employer, this is what's happened, we do need you to make these changes and just prevent another accident from happening. So sometimes it is unfortunately the case of it has to wait until the person's been injured before a company does make those changes. Or even through the claim, that's when the changes are made.
I think one thing they don't like as well, companies, is bad publicity. You know, if somebody actually gets killed at the workplace, obviously it gets reported.
Yeah, definitely. I've seen situations before where I've helped people where the company has been prosecuted. It's then reported in the papers. But at the end of the day, if the company didn't complete the negligence, this wouldn't happen to you.
In the first place.
Yeah, exactly.
Yeah. Okay, Alex.
It can, of course, result in fines. And sometimes in the worst case scenario, directors can, of course, be dismissed as well.
Or jail, but very rare.
Yeah, it's very rare, but and like I said, these situations shouldn't be happening.
No. Okay then, so what about preventing injuries and fighting for safer workplaces collectively?
Yeah, of course. So like I said, I think in situations, warehouses, for example, it can unfortunately be quite common for unsafe practices to happen. It's important to, of course, contact the union representative to decide what is happening. Some people can feel vulnerable because they're worried about being dismissed just because they've had an accident or because they complain about these situations. And you shouldn't be dismissed if you have made a personal injury claim, because you may have a claim for unfair dismissal. Of course, there is more protection there if you have been there for more than 2 years. But of course, more people that complain about these practices, the more likely a company is likely to change that.
Yeah, but you're covered for health and safety from day one.
Yes, definitely. It doesn't matter if you've been there 1 year or 10 years, you are protected as soon as you start your employment with the company. And that extends to agency workers as well. It doesn't matter if you've got a full-term contract or if you are an agency worker, you're protected exactly the same.
I think an example of that, with the joint action as well, is I've personally been involved in things like this. One of them was working with fiberglass. I worked in a body shop, rebuilding and repairing buses, and we used to work with fiberglass, and we used to cut the fiberglass with air tools, and you could see the glass, especially on a sunny day, glittering in the air, and there was a concern that we were breathing this in, and it could be the next mesothelioma, it could cause that. So as a group, and I think there were 200 of us from Leeds, Bradford, Halifax, and Huddersfield, we said we're not going to work with this fiberglass until we've had tests. So they sent out, the company did what they should have done. They sent us all for tests to make sure everything was clear, and they weren't providing the correct equipment. I'm talking 30 years ago now, but they did invest, and we made the workplace safer through joint action.
Yeah, definitely. I think that collective action is definitely a strong way to get things changed. I know you've touched on there about, again, these health safety checks. It's important if you're using, say, for example, vibrating tools, or if you're exposed to chemicals or dust, you do need to get health and safety screening, which the company has to provide. You have to be checked these conditions aren't happening. And if they are, for example, carpal tunnel syndrome, changes do need to be made. If you're using vibrating tools, for example, they have to reduce the amount of time that you spend on those vibrating tools or just take you away from them, because it could just make things worse for you.
Yeah, I've dealt with a number of cases with white finger through using vibrating tools, flair tools as well, because they're cold.
Yeah, definitely, exactly. Sometimes, fortunately, the health and safety has improved for a lot of companies and have things such as ready reckoners now, where they actually monitor the amount of vibration and exposure employees have to these equipment. But a lot of times, I've seen situations before where they just aren't recorded properly. Sometimes people can be working their entire shift on vibrating tools, and which is clearly unsafe, and the company just say that's part of the job, which isn't enough. If you are using tools which do put you at danger, your role does need to be varied, say on different tools or just completely off tools as part of the shifts, and you do need regular breaks.
Job rotation, doing different jobs, yeah.
Definitely. And it's not just for right tools. For example, if you work in a warehouse or on a conveyor belt, you can't just be stuck doing the same job for your full shift without any breaks, because that is a foreseeable risk of injury from developing.
Yeah, good. So why such work is important? Let's have a look. It's talking about how unions can make a difference. I think on that one, how unions can make a difference is union reps should be trained as in regards to health and safety. And we're talking about with the EFWU doing a little bit of training on this. But unions can help by looking at laws, looking on the various sites, the HSE site, ACAS. I think they have things on ACAS, health and safety.
Yeah, they do. They provide free advice at ACAS. But I think, for example, the union, it's a good scheme to have, and there's a lot of employers that don't have union representatives, but it is someone to fight your corner. Sometimes you don't think that you need to speak to a solicitor, and I think that if they've just got a concern about something, it's too extreme to speak to a solicitor, but they could go to a union representative who can give you some advice in terms of how to prevent an injury or to how to change working practices. So it's definitely useful for someone to have.
Yeah, but possibly the first port of call, and
Definitely.
So we'll move on to segment 5 now, real life cases from Alex. Have you got any examples that you can share with us of real life examples?
Yeah, of course.
I know you've shared one already about the lorry driver, haven't you?
So I've got quite a few examples, but to start with, I did have this gentleman that came to me that was asked to lift some glass, but he didn't have any protective gloves. So unfortunately, when he was lifting the sheet of glass, this of course lacerated his hand when it slipped. Initially, he did think that it was just a cut to the hand, but it later became apparent that this, of course, was impacting him on his daily life. It was impacting his grip. It was his dominant hand as well, the hand that he wrote with, so it was really impacting him with his daily tasks. So we got a medical expert instructed in his case from a hand surgeon, and the hand surgeon actually said that the client had some nerve damage, and because of that we actually managed to get some private surgery and some private hand therapy arranged for him, and the client received over £30,000. In that situation, if he hadn't made the claim, it's very unlikely that he would have been treated as he had, because those treatments just weren't available on the NHS at that point. So sometimes with a claim, it's not just in terms of the monetary side, it's just getting that extra treatment. It's especially key in terms of, say, people that are suffering psychologically, just because I've seen so many situations where I've got a gentleman at the moment, he's been waiting 3 to 4 years, he's had a very serious accident, he's still not getting any psychological support on the NHS. So sometimes just as part of the claim, you can just get extra treatment that wouldn't be available.
Yeah, okay. Do you think there's a culture of trying to blame the worker?
Sometimes, yeah, I have seen that, unfortunately. I mean, even, for example, I've dealt with a case where another employee has actually assaulted another employee, and the company are aware that this person had made threats to my client before and they'd failed to do something. The employer can't simply blame the other person's actions. At the end of the day, the employer has the overall duty to protect the person's safety, whether it's from an employee, from the equipment, their working practices or anything else. The ultimate responsible party is the employer.
Okay, what we're going to talk about now is hidden hazards workers overlook. So what kind of hidden hazards do we see? Any examples such as inadequate staffing, creating unsafe pressure, lack of training or poor induction for new staff, no proper PPE, that's personal protective equipment, or faulty equipment, ignored complaints or hazard. If a worker's complained about something and it's been ignored, work-related stress due to unmanageable workloads or bullying, and overworked staff not being given breaks or safe shift patterns. Quite a bit to go at there, Alex. So would sort of like to try and cover, maybe not them all, but some of them?
Yeah, of course. Unfortunately, I've seen examples of all of those. Fortunately, different companies, they are quite common. One particular example is delivery companies or people working in warehouses. They can be set very unrealistic targets where they do feel pressured. Sometimes they're having to work when they're short staffed, so they're essentially having to cover the jobs for 2 people. So say, for example, a delivery person, there's supposed to be 2 people in the van assisting with lifting. they're sent out by themselves, they're having to lift, say, 30-kilogram washing machines by themselves, which is clearly unsafe. And I think as well, when you set these unrealistic targets, people are stressed from a psychological perspective, but it also does put them at an increased risk of harm. They may be taking shortcuts, they may have to do things unsafely just to meet these targets. And just going back to your point about where companies try and blame employees, that's a situation where this can happen, where employers can put people under unsafe working practices and then say it's their fault for getting injured. It's just simply not enough. At the end of the day, you can train someone, but if you don't provide them with the correct circumstances to implement that training, it just can't be followed.
And unrealistic targets as well, you know. I know some delivery drivers, which you've already mentioned, for various supermarkets, they're giving unreasonable targets, so they're having to drive faster than what they should be, or taking shortcuts, things like that.
Yeah, definitely. And I think it's a shame as well where some people are trying their best to meet these targets, and then when something goes wrong, the employer tries to blame the employee. It just isn't adequate. At the end of the day, it have to be realistic targets. Because like I said, otherwise people are at risk of harm. Sometimes they've got 3 minutes to deliver something, for example, which just isn't enough. And then sometimes they can be disciplined if they don't meet the targets. They can't really win either situation.
Yeah. And I think we need to highlight as well, it's a cost to the company, isn't it? Because if somebody is injured and they're off work sick, that job's still there. Somebody's got to do that job. So they might have to employ somebody else to do their job while they're off sick. So it is a cost to the company. And obviously, possibly, as we've said before, bad publicity, which they don't want bad publicity. Okay. So we've just got a few short questions. Okay. So number one, if I make a claim, will I lose my job?
No, you shouldn't lose your job because you've made a claim. The company shouldn't discriminate against you just because you've made the claim. Like I said, employees do have more protection if they have been there for at least 2 years, but regardless of how long you've been there, you can't be dismissed solely because of making the claim, because you could potentially have grounds for unfair dismissal. Okay.
What would I do if I were being victimised because I've made a claim?
You do have protection against victimisation as well. The law says that you can't be victimised just because you've made the claim. They shouldn't treat you any more differently, whether you've made the claim or not. Your job should be protected. The company shouldn't change how they treat you. They can't change, say, for example, the shift they provide you. That you can't suddenly be dismissed. You can't lose your hours just because of that.
Yeah, because I have had examples of members going to management, they've had an accident, and then again, the management are trying to blame the worker.
Yes.
And it has been said to them, if you don't put a claim in, we won't discipline you. Yeah, and I've seen that happen, which is disgraceful.
Yeah, definitely. I've seen that situation before. I've even seen companies say, we'll offer you X amount of money if you don't claim against us. Or they basically make someone sign what's called a settlement agreement to basically waive the rights to make a claim if they'll accept X amount of money. Unfortunately, situations like that, I've seen people that are very vulnerable who maybe don't understand the agreement and they feel that they've been presented with some paper that they just have to sign because otherwise they feel they could be dismissed, which is very unfair.
And then you'd argue that that was signed under duress.
Yeah, definitely.
Yeah. Okay, another question. You can't claim if you're an agency worker, is that true?
No, that's completely false. And many of my clients are actually agency workers. Where there is an agency involved, you have to consider which of the companies is most responsible. Is it the agency or is it the company where the accidents happened? In say the majority of cases, it is the company where the accidents happened. And because they're the one that are responsible for the people around them, they're responsible for the equipment, for the actual premises itself. So like I say, the majority of the time, it is the company that they're being sent to work for and the agency isn't involved in the claim.
Yeah, even if you're an agency worker.
Yeah.
That's worth knowing. Stress doesn't count as a real injury, is that true?
No, that's false. Personal injury includes physical and psychological injuries. Like I said before, whether you have physical injury or not, it doesn't prevent you from claiming. I've got many clients where they have suffered, say, for example, post-traumatic stress disorder. They have depression or anxiety because of the working conditions, and all those things are claimable. The company is still under a duty to protect you from stress at work and psychological symptoms too.
Oh, great. Good advice. And the last question, you need to go to court to make a claim, is that true?
No, that is one of the regular questions and concerns that I have from clients. It's completely false. In the last 4 years, for example, I've only had 2 cases go to trial, and it's situations where liability is firmly denied. In the vast majority of cases, we do just reach an agreement with the defendant's representatives. Where liability is admitted, it's very rare, but if it does go to court, it's only because the defendants are offering a very unreasonable amount. At the end of the day, though, it's always up to the client if they do want to accept an offer or if they do want to keep going and pushing for that court hearing. Even where liability is denied, it's very rare for it to get to court because, like I said, the majority of the cases, we do just reach an agreement with the defendant's representatives.
Yeah.
It's not really worth it in most cases for them to go to a court hearing because the defendants are aware that if the case does succeed, they will owe a vast majority more of costs if they do proceed to the hearing. So it's just not worth it financially for the majority of cases.
Yeah, and I suppose as well, and we talked about this earlier before we started the interview, you've got to manage their expectations as well. Yeah.
Yes, if liability is denied, there's many cases I'm still happy with things, and I will tell clients I'm still happy with the case and still happy to continue with that. But if I don't think there's any more prospects of success going forward, I'm concerned that the case could fail by pushing through the court process, I will tell a client about that. I'm not going to force them to go through that process when the case could fail. And so I'm always open and honest, and I do, of course, explain this as early as possible. I'm not going to wait, say, 3 years down the line and then tell them suddenly I can't carry on with the case.
Yeah.
I'm realistic from the outset, and as things change in terms of evidence, I will just update my view as well.
Yeah, and I think it's important that you don't make any promises like, saying, you should get about 20, 30,000 for that. You don't make any promises like that.
No. I've seen situations before where clients have said, oh, well, I've spoken to this solicitors and they've promised them this. And in the majority of cases, it's so difficult to advise, especially say if an injury's happened last week. We don't know how it's going to develop. I've sometimes had cases where the injury seems pretty straightforward. Say, for example, just an elbow fracture, and then the client's needed 4 or 5 surgeries down the line because of complications, and suddenly it's a £200,000 case. Or we've had situations before where the financial losses are actually way more than the injuries because people are not able to work, or it could impact how they can work in the future. So it's just impossible to give someone a value at such an early stage. So we'll be honest with you, just as soon as we get the medical evidence and as soon as we can value that case, we will provide that information, but we just don't want to give you a false promise.
Yeah. Okay, Alex, I think that's brilliant advice that you've given today, and examples of injuries and what to do if you are having an injury. And I hope to all our members out there that, you take this on board and it is useful advice. And if you're not a member of the union, I'd advise you to join our union, join the EFWU, and we will take your case forward. You've got somebody on your side and somebody to speak to. And again, Alex, thanks very much for joining us today. Thank you.
Thank you.